Hello everyone, welcome to India for IAS. My name is Shreyas and this is a discussion video on the polity and governance test. So already now nodange test 2 was dedicated to polity. So adralli certain part of the syllabus now cover madidvi. So this is the second part of the polity syllabus. So if we complete that and this together, then we have finished one round of complete polity and governance part. So same, even in this paper I will be using the same set of things, such as I will be dividing the paper into different kinds of tick marks colored differently. Green color tick mark andre it means that it is a level 1 or level 2 question, or it is a easy question which is easily covered in your standard book. Orange color tick mark means there is certain extra information which you may not have read or may not have come across. So there you please make a note of that information because it is important. Purple color tick mark means there is certain set of tricks which could be applied to get the right option or eliminate the other options. X mark means it is better that we skip this question because it is difficult and aspirants will mostly make the mistake in such sort of questions. Before we proceed on, a brief description about the paper. See, paper 2 syllabus, there were more important parts of the polity syllabus, be it preamble, be it DPSP, be it central government or parliament, and so on. In this paper, there is less relatively important segments in certain parts, for instance constitutional bodies, statutory bodies, and so on. But there is also certain important part of the syllabus in this, for example Supreme Court, subordinate courts, and so on. So I will be telling few areas where you need to focus more in this paper, and certain areas in certain questions I have not marked it in any of the inks. So that means that those questions are less important, so you need not worry much about the less important part. But when you are attempting this paper, if you got a question wrong over Article 371, which is the special status given to certain states, so ಆ part ಅಲ್ಲಿ ನೀವು question wrong ಮಾಡಿದ್ರೆ you need not worry much because there is less chance that UPSC might ask those questions. ಆದರೆ in case you made mistakes in simple questions which were on Supreme Court, then you need to re-revise and you need to rethink why is that you are doing those questions wrong. So likewise, if you get low score in this paper overall, do not worry too much because there are certain questions which are less relevant, but there are questions which are relevant also. So you need to divide the paper and see where you made the mistake. Is it in the most important part or is it in the lesser important part, and so on. You need to judge yourself. Sarina? So we'll begin the discussion. So with reference to organizational bodies in India, consider the following statements. National Consumer Disputes Redressal Commission. Okay. Now see this, National Human Rights Commission is a constitutional body. Now here you should be aware of which are the constitutional bodies and which are not. So this is basic. You should know that NHRC is a statutory body, it is not a constitutional. Though you did not know the first statement, you should know the second statement if you are studying seriously. So look at the third statement. Law Commission was first established by Charter Act of 1833 and it was chaired by Lord Macaulay. This has been very well given in Spectrum book as well as in Lakshmikant book. So there is no way that you should be getting this as wrong. Now this statement is correct. Now even if you had solved or deduced these two statements, first statement, even if you did not know, you could have done 50-50 among only one or only two options. Now let us look at the first statement. National Consumer Dispute Redressal Commission was established under Consumer Protection Act. Now you may not have come across this fact, but this is a fact, so please make a note of it. National Consumer Dispute Redressal Commission, it is established under Consumer Protection Act of 1986. Please make a note of it. Other way to think, even if you did not know about this, just think that there is something called Consumer Disputes Redressal Commission, which seems like an important body, and that will be established under some Consumer Protection Act itself. So in that sense also you could have known that when it comes to Consumer Protection Act, the most famous or the only one which we can recall is this 1986 Act. So if you had come across this act, then also you could have thought this statement to be mostly correct. So ಆ ಥರನೂ think ಮಾಡಬಹುದಿತ್ತು. Let us go to second question. With reference to NIA, see, now NIA you might have studied. One thing which I wanted to add is, we know that NIA was established in the aftermath of 26/11 Mumbai terror attack. What does it will investigate? Offences related to smuggling, arms, drugs, and counterfeit currency. Now I expect you to know about these two. Now obviously NIA you may not have come across or studied in Lakshmikant, but when you study the current affairs part, be it internal security or when you have done your basic foundation for internal security sort of syllabus, then you would have come across this. So these two statements I expect you to know, but there was a development that happened. NIA Act was amended in the year 2019. So certain changes have been made, and this statement is picked from the changes that were made. So it has the authority to investigate offences that are committed inside Indian territory only. Now this is wrong. Earlier it could only investigate crimes which happened only in Indian territory, but now it can also do it outside. So this was a recent development that happened in 2019 Act. So idu gottirlilla andruno, it can investigate offences only in Indian territory only. So only basis mail you could have thought it to be wrong, in case if you did not know this. Moving on. Now again an important question over Attorney General. Now Attorney General is an important topic, we need to be aware of it. So Attorney General, highest legal officer, okay, responsible for representing both the central as well as state government in all legal matters. Now see, Attorney General is for the center and Advocate General is for the state. Here there is a trap which will make it wrong. Next, the AGI can refuse to represent the central government in cases where they believe the government's stance is unconstitutional. Okay, we'll come across it. AGI is barred from holding any private legal practice during their tenure. AGI is not barred, and if you have studied about Attorney General, you would be aware of this thing. So this is wrong, this is wrong. This is something which we are made to think on spot. So AGI can refuse to represent the central government in cases where they believe government stance is unconstitutional. Just think of the office of AGI. AGI is not an office under central government. It is a constitutional post. It is a constitutional post. And when it is a constitutional post, they will have certain discretion to not obey with the government at times when required. So ee tara now think madidre, we would have taken this statement to be correct. Couple of things about AGI. See, AGI office, as we know, it is under Article 7, established under Article 76. So AGI holds office during the pleasure of the president. So AGI does not have a fixed tenure of 5 years, 3 years anta enu illa. As much as the president wants the AGI to hold the office on the advice of the cabinet, only till then will the AGI hold. So AGI is allowed to make a private, he can do his private practice also, because it is not a job under the central government. It is not of office under the central government. So he is not considered central government officer as such. So he can do his private legal practice as well. But whenever any issues come, then AGI is supposed to represent the central government in courts or fight the litigation cases which have been put on the central government. But state government anta bandaga, it is not Attorney General, it is Advocate General, which is office under Article 165. I hope you know this. For example, 76 admele illi 1 add madkoli, 7 minus 1 6, 6 minus 1 5. This is how you can reduce articles from central government to state government. Okay, we'll move on. See, no, Advocate General, Attorney General, these are important things, and basic things like 4-5 facts about it we are supposed to know. So next question. Supreme Court can overturn the initially declared results of urban local body selection and declare another person as a winner by invoking Article 142. Okay, Article 142 allows the Supreme Court to go beyond the confines of existing law or statutes to ensure justice for all parties involved. See, suppose if you did not know about Article 142, just think how you could have answered this question. Statement 1 and Statement 2 are reinforcing each other. I have told this even in previous classes that even if you do not know the concept in the question, then if Statement 1 or Statement 2, if they are reinforcing each other, that means that option answer will be A. This was one way of doing it if you did not know what Article 142 is, but It is good if you know what Article 142 is, because it will be helpful even when you are writing the mains answer. Sometimes even a test series dedicated question was asked on Article 142. So Article 142, Supreme Court will have the power to make complete justice. So where the justice is denied, in such cases it has the provision to make complete justice to Article 142. So what does it do? For example, Chandigarh mayor election alli, Chandigarh municipal corporation mayor election alli, there was little bit issues with respect to the election that was been held. So Supreme Court intervened using Article 142 and it declared the election to be void and made re-election possible. Now this is an extra power. So Article 142, it has been told in the Constitution also that this power needs to be used very sparingly, because Supreme Court can enter any domain of the government and it can do such changes. So it needs to be used very, very sparingly and used only when there is a need to make complete justice. Okay, we'll move ahead. Which of the following best describes the difference between anticipatory bail and interim bail? Now this is a new thing and I do not expect you people to know this, and the statements that were framed were also very delicate, such that you cannot easily make out as to which statement is wrong or which statement is correct. So if you did not know anything in this question, then it was better meant to be left, but see few of the statements here. For example, there is no difference in anticipatory bail and interim bail, and they are interchangeably terms used in Indian law. See, ivala sumne, they want you to take it as wrong, and that is why the statement is been given. So D hengidre eliminate madirtira. So next, what else is remaining? Anticipatory is bail is granted before an arrest, while interim bail is temporary relief granted. Okay. So these three statements, it is difficult to make out, but D you could have eliminated. So if it was choosing among two options, then we could have taken a guess. But since it is three, it becomes difficult to deduce. So it was better meant to be left. This question was better meant to be left, but I want you to make certain additions in your notes with respect to the bail system that is there. So briefly I'll talk about it. See, bail. Simple words, bail and reno. A person is been arrested and we want the release of that person. So we'll deposit a certain amount of money and we'll get the bail. So where do we get the bail from? It is from the court. So bail has certain types ide. One is regular bail, one is statutory, one is anticipatory, and another one is regular, statutory, anticipatory, and another one is interim bail. Okay, we'll just get a basic idea of what this is, because there are at times UPSC does go into this governance sort of questions which we are not prepared. So one basic idea really, see, regular bail means court has heard the case and has given the bail. Simple thing. Statutory bail means you get this bail as a matter of right. For example, the investigating officers or the police officers, they delay filing FIR or charges against the accused person. So in that case, you cannot hold the accused person under custody for a long duration of time, because only because of the investigation delay that they are been held, the accused has been held. So in such case, the accused as a right, he can claim statutory bail from the court. This is due to delay by the investigating agencies or the police. So anticipatory bail means it is called pre-arrest bail. So arrest madakinta munchene we will try to get this bail from the court. So anticipatory bail, it is a discretionary thing for the court. The court may give for certain persons and it may not give for certain persons. And anticipatory bail tagombekanದ್ರೆ, then he has to go to High Court or he has to go to Sessions Court only. He cannot get it from other courts. Another one is interim. Name itself tells interim means temporary. It is a bail that is taken for a temporary and short period. That too when the regular bail has not been granted yet. The regular bail thing is still going on. So during that point of time, instead of just waiting, they take an interim bail for a short duration of time. So this was a basic idea about this. So we'll move to next question. Question number 6, K.S. Puttaswamy judgment. I hope everyone would have heard about it. Now look at the statements. None of this we would have come across, or none of this we are able to easily deduce. So this was a question that was meant to be skipped, because legality, consistency, need, proportionality, all of this seem very familiar. So in this question we would have gone with 1, 2, 3, 4, but that is not the answer. So this was a question that was meant to be skipped, and these sort of things rarely UPSC ask. And even if it asks, the things might change here in the actual paper. But one thing we need to notice, K.S. Puttaswamy judgment, it is related to right to privacy, which the UPSC court had told. We'll move on. See, question on Supreme Court, easy question, I'll leave it to you. Okay, right to die with dignity. Okay, I'll leave it to you. Question on district court. Okay, easy question, I'll leave it to you. Question on state legislature and question on parliament and state legislature. Okay, jurisdiction. Easy question, I'll leave it to you. Consider the following statements on State Public Service Commission. Okay. Now this is also easy question, because basic things like Election Commission, UPSC, Office of CAG, Comptroller or Auditor General, UPSC and SPSC, which are very closely related. These things, at least basic idea we should know. Because though these constitutional bodies, though they are not important from prelims perspective that much, they are important from mains perspective. So constitutional, non-constitutional bodies na differentiate madbekanu, constitutional bodies are more important than the non-constitutional. Okay, see, now this is a fact which I want you to make a note of. The governor can exclude post services and matters from the purview of SPSC. Now this is an incomplete statement as such, but this is correct. The governor can exclude post service and matters from the purview of SPSC, but such regulation needs to get the approval of the state legislature. So it is actually the state legislature that will approve the changes with respect to excluding these services from SPSC. Like we studied, SPSC, the jurisdiction of SPSC could be varied by the state legislature. So this is just a manifestation of it. But it is the governor who shall be doing it, but he should get the approval of state legislature. And rest of the things, it is easy, I'll leave it to you. Because these are questions directly picked from your notes or your Lakshmikant. Okay, I want to talk about this. How many of the above are subsumed under GST tax regime? So there were so many taxes and so many taxes got subsumed under GST tax regime. So which are those taxes? Countervailing duty, it has got subsumed. Excise duty, it has got subsumed. Entertainment tax has got subsumed, yes, but it is not of the local bodies. Local bodies domain na hage ittidare. GST li local bodies related tax system na tumba jasti tagondbandilla. So this is wrong. Luxury tax, yes. Taxes on lottery, yes. Special additional duty on customs, yes. Do not confuse, customs is not under GST. It is only special additional duty on customs that is there. So the answer to this question is 5. Couple of things else which I want to tell. For example, now under GST, there are certain taxes which are not brought under GST and you should be aware of it. One is excise and VAT, excise of central and VAT of state on alcohol. Now you should know this. And excise on, see there are 4 things. One is petrol, another one is diesel, another one is, I think it is kerosene, and another one is aviation turbine fuel, ATF. I think it is kerosene, please check. So there are 4 things which are kept. These 4 things, excise and VAT on alcohol. These are the things which are as of now kept outside the purview of GST. because states, they do not want to give their VAT over alcohol. But in the future, this may be subsumed under GST. In case if it is subsumed, that year this question will become more important. We'll move on. Okay. See, in this question, you might feel, why have I tick marked each in different colors? Because see, now this is an important thing which I want you to know. That is why I marked it in orange. And in this question, you could have eliminated, or you could have found some trap. So that is why I marked it from purple. Because the statements here itself are very, each statement is giving different sort of hint. One is easy, one is giving guesswork, one needs certain degree of value addition. So that is why I have done it this way. So in which scenario would a member of parliament or MLA not face disqualification and anti-defection? Now anti-defection, 52nd amendment, which schedule? So what are the provisions? There are 4 provisions for anti-defection. You should know this by heart. So what are they given? If a member votes abstains, now this is something which you should know. If a political party, now this is not been given, so that is why I wanted you. See, if a political party makes a merger, in case of merger, if a political party makes a merger with another party and that merger is been supported by 2/3 of its members, if 2/3 of a particular party A want to join another particular party B, then 2/3, if 2/3 of party A people are agreeing to make that merger, then it won't result in anti-defection. Only if it's less than 2/3, then it will result in anti-defection. So they have given 51% here. So this is what I wanted you to make note of. So if a nominated member joins a political party within 6 months of nomination, then it would result in anti-defection. It is not within, it is after 6 months. If a nominated member joins the political party after 6 months, then it would result in anti-defection. This has been asked in 2022 PYQ of UPSC, and there also they had confused students by before and after. So please be very careful. Please have a clean idea of whether it is before or after. See, a member of ML or MP, he'll have 5-year term. So in this 5-year term, we do not want the nominated member to join the other party or the ruling party. So what do? We will give him minimum tenure. We'll give him minimum timeline where he could join the party. So we'll give him only for 6 months. Usually because in this first 6 months, even that party wouldn't have a clean idea of this nominated member. So the nominated member, less chances that he'll join the ruling party within the first 6 months. So ee ತರ ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು. So first 6 months ಅವ್ರು ಇವ್ರಿಗೆ ಸೇರಿಸ್ಕೊಳ್ಳಲ್ಲ. So ಇವ್ರು first 6 months ಜಾಯಿನ್ ಆಗಕ್ಕಾಗಲ್ಲ. After 6 months ಆದ್ರೆ next 4.5 years ಇರುತ್ತಲ್ಲ. So in that tenure, there is good chance that this nominated member might join the party. But if he joins, then anti-defection will be applicable. So basically, we are making the nominated member, we are reducing the chances of nominated member to join the political party or the ruling party. Okay, we'll move ahead. Following statements regarding right to information. Now RTA, I hope you have come across things of this, but things which I wanted to tell about RTA. Now RTA, you know, under it is backed by RTA Act, and say here it is told 90 days of receiving the request. See, whenever RTA request is made, it is the responsibility to provide that information within 30 days, not 90 days. Nodi, usually numbers are trap kodtare, be very careful. So in case if you studied RTA long time ago and you forgot it is 30 days, but when you see that 90 days number, it is a very large number compared to 30. At least avag nimge ಒಂದು estimation ಬರಬೇಕು. 30 days 40 days ಇಲ್ಲೇ ಎಲ್ಲೋ ಹತ್ರ ಇತ್ತಲ್ಲ, 90 days ಅನ್ನೋದು ತುಂಬಾ ಮುಂದಾಗೋಯ್ತು. So 90 days ಅಲ್ಲ. I'm not sure whether it is 30, but I'm very sure that it is not 90. ಇಷ್ಟು ನಿಮಗೆ ಗೊತ್ತಿದ್ರು you could have easily eliminated this statement. So only citizens of India registered in India have the right to seek information under right to information. We'll come across this later. There is no prescribed format. Okay, this seems true because RTA, so many people even with less education or so many people want to get information from RTA, and we do not want to make it too much formal. But it should have the name and complete postal address. Okay. Another one is, if the applicant belongs to BPL category, he or she is not required to pay any fee. Nodi, these are basic things. Now BPL idda, so that's why we exempted him from paying the fee. Now these statements tend to be correct. Idರಲ್ಲಿ ಏನು doubt ಪಡೋ necessity ಇಲ್ಲ. Now even see here, this RTI thing, we want majority of the people to participate in it. So instead of, we do not want to prescribe a stringent format or very formalize the process such that most people are not included. So that is why we keep it simple. We just give the name as well as the complete postal address ಅಷ್ಟೇ. So 3, 4 are correct. Statement 1 ಬಗ್ಗೆ ನಿಮ್ಗೆ ಆಲ್ರೆಡಿ ಗೊತ್ತಿರಬೇಕು. Now look at statement 2. Only citizens of India registered in India, okay, citizens of India and associations registered in India have the right to seek information. Now here I want you to make note of is, RTI can only be claimed by individual, means a citizen. It cannot be claimed by legal entities. Legal entities means associations, corporations, companies. They cannot make a claim to RTI. It is only individual person or the citizen of India who can make a claim to RTI. See, idanne different way alli kelbodu. RTI, which of the above person are eligible to get information under RTI? Option A, citizen of India. Option B, legal entities in India. Option C, both citizens and foreigners residing in India. ಈ ತರನು UPSC ಕೇಳೋ ಚಾನ್ಸಸ್ ಇದೆ. So please be very careful. We'll move on. Question number 14. See, National Population Register here, just a simple thing which I wanted to tell. National Population Register, this was done around 2015, but here they are telling that it is prepared under Citizenship Amendment Act 2019. So how can it be done earlier? It was done earlier in 2015. Then how can it be prepared under 2019 Act? So it is wrong. It was prepared under Citizenship Act of 1955. So ಇದು ಒಂದೇ ಟ್ರ್ಯಾಪ್ ಇತ್ತು. This thing you should know that it is the Office of Registrar General who is responsible for NPR. Officer of Registrar General or Census Commissioner, he is the person responsible for doing the census as well. And the Census Commissioner, his office is under Home Ministry. Another fact. Okay. Consider the following statements. Currently, the net divisible pool of tax revenue consists of this after deduction of cesses, surcharge. This is a correct statement. I hope you got this correct. Because nodi, gross, out of the gross tax revenue, we will subtract the cost of collection. Along with that, we will subtract cesses and surcharge, because cess and surcharge, they are not shared with the states. It is only with it is only kept by the central government or the center. So this is correct. Share of cess in gross tax revenue has consistently increased over the last 5 years. See, I have told in previous test discussions also that consistently increase, consistently decrease and bandre extra careful agbeku. So we'll nodi the share of cess in gross tax revenue. If it was only share of cess, then that would have been different thing. Here it is telling cess as a percentage of gross tax revenue, and this is increasing. Now this is very difficult to tell, because the gross tax revenue itself could vary. It could increase a particular year or it could decrease. So since this is also involved, even if you are increasing the cess year by year, but because of cess to GTR ratio, it will not be consistently increasing or consistently decreasing in commonly. So this will be wrong. So that is why I marked it as purple color, which is meant for certain trick. And this I marked it as green because I want you to know, because this is very simple thing you should know. Now this is an orange thing because this we would not have been come across. Corporation tax and custom duties, they were absorbed only by the union and not shared with the states before the 2000 year. Then after 80th constitutional amendment, customs duty and corporation tax were involved in the net divisible pool of taxes. So this is what we should know. We can even use these facts in mains when there is a question on distribution of revenue has become a source of contention between center and state. So in such questions we can use this. See, this question matte nanu helangire, this you could have deduced, this you could have deduced, only this thing is there. So 3 na wrong anta helidre 2 correct ಆಗ್ತಿತ್ತು. So ಅವಾಗ A ಅಥವಾ B ಮಧ್ಯೆ you should have taken a option. You should have taken a guess. because you cannot leave the question when you are reduced to two options. Which of the following will have to be determined by the respective states as per 73rd Constitutional Amendment? See, this is a simple question. This is basic. You should know. This was left. Okay. Financial powers to panchayats was also been left. Matters relating to election. Matters relating to connection with elections of the panchayat. Okay. This was also left. Number of tiers was not left to be decided by the states. It was a compulsory provision. But in the solution, I found that even this has been taken as conditional, which is wrong. So answer is 134. See, now panchayats, in these questions, I do not want to dwell deep because these are direct questions and you should answer it. Consider the following statements with regarding Indian and American Supreme Court. Okay. Both Indian and American Supreme Court original jurisdiction lie with the cases only related to disputes among. No, you know about the Indian. You know about the Indian's Supreme Court. It can take civil cases. It can take criminal cases also under its original jurisdiction, but it should be of certain value. For example, criminal cases, I think it is 7 or 10. I think it is 10 years. If it is resulting in imprisonment of more than 10 years, then you can directly approach Supreme Court. Center and state disputes. Okay. Okay, again the power of judicial review of American Supreme Court was established through one of its cases. While in India it is implied under Article 13 and Article 32. This is correct, but now you should know that in America, though judicial review was there for a long period of time, it came through one of its courses. It came through one of its Supreme Court cases. Supreme Court of America gave a doctrine of judicial review in one of its cases. I think it was, I'm not able to recall the name, but it was in one of the cases. But in India, it was not through one of its cases. It has been implicitly picked up from Article 13 and 32 of the Constitution. Now, this is what we had learned. But please be careful. I don't think UPSC will be asking this question, but in one of the UPSC PYQ itself, it has been given that judicial review is been provided by the Constitution. This was the statement, and UPSC has taken that statement to be wrong. You can go and check. I think it is 2022 paper or 2023 paper, either of this. You can go and check. So judicial review is provided by the Constitution. Now ಓದಿದಾಗ it is under Article 13 the judicial review is been provided. ಇದನ್ನು ಟೆಸ್ಟ್ ಸೀರೀಸ್ ಅಲ್ಲಿ ನೋಡಿದ್ವಿ, ಲಕ್ಷ್ಮೀಕಾಂತ್ ಅಲ್ಲಿ ನೋಡಿದ್ವಿ, ಬಟ್ UPSC ಆನ್ಸರ್ ಕಿ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ತೆಗೆದಿತ್ತು. ಸೊ ಈ ತರ ಕ್ವಶನ್ಸ್ ಮೇಲೆ UPSC will not ask the question because it has taken out a controversial answer key already. So that you to be aware of, and this is simple thing which you should know. Indian Supreme Court jurisdiction powers enlarged by the Parliament. American Supreme Court is limited to conferred by the Constitution. Correct. Okay, we'll move ahead. Consider the following statements with respect to language in state legislature. Now, this is a simple thing, but few things which I want you to make note of. See, newly elected member of Legislative Assembly shall take oath only in languages that are mentioned in the 8th schedule. This is a wrong thing. See, 8th schedule, there are 22 official languages, and other than these languages also, a person can take oath in. So, only kuda kottidare. So, only languages, restricting his freedom of speech in that particular language. So, this is wrong. This we could have made a guess. So, when the governor is satisfied that a substantial portion of the population of state desire, then he shall consider it to be officially recognized language in the state. See, Illinois, I had told in previous sessions that UPSC will make, UPSC or even this test series will make a word play between governor and president. It is the president, not the governor. So, officially recognizing of a language to be used in a particular state, then that is done by the president and not the governor. So, this is wrong. And other two statements, they were direct, which were easy and you should have managed. See, for example, presiding officer can permit a member to address the house in his mother tongue, which is correct. Legislature of a state may adopt any one or more of the languages in use in state as the official language. These are correct. So, 1 is correct, 2 is correct, 4 is wrong, 3 is wrong. So, answer becomes only 2. Consider the following statements with reference to national Council for Teacher Education. See, I have not marked anything because I leave it to you. You can dwell into it or you can just have a glance. Question on NGOs. See, here also a new thing. We know about NGOs, why NGOs are formed. Then there was FCRA, Foreign Contribution Regulation Act, to regulate the NGOs that were getting substantial amount of funding from international personnel or bodies. So FCRA, they are regulated by Home Ministry. This is correct. Now this you should know. Office bearers of NGOs receiving more than 10 lakh annually donation from abroad, they are treated as public servants when it comes to anti-corruption law. Now this is something which I want you to make note of. Any NGO bearer, if he or she is receiving more than 10 lakh annual donations from abroad, then they shall be treated as public servants for anti-corruption law. Now this is correct, but we would have not come across it. So ಇಲ್ಲಿ ನೋಡಿ, statement 1 ಗೊತ್ತಿದೆ, statement 2 ಗೊತ್ತಿಲ್ಲ, statement 2 correct wrong ಅಂತ ಹೇಳೋದು ಕಷ್ಟ. So either ನಾವು 10 lakh ಅಂತ wrong ಅಂತ ತಗೊಂಡು statement 1 only 1 ಅಂತ ಹೋಗ್ತಿದ್ವಿ, option A, or if we knew about this, then we would have gone with C. So at least one statement, even if we had got it as correct, if we knew statement 1, then we have to take an attempt in this question, because there are only two options left. Either it will be A or it will be C. So when you have to choose between two options, you have to take or you have to attempt the question. Who among the following has authority to alter the boundaries of scheduled areas? Now these are simple things which I'll leave. Who can be returning officer for election of president, vice president? You should know it. Okay, members of State Public Service Commission, they are appointed by the governor of the state but removed by the president. This is correct. State Election Commissioner appointment is done by the governor, but conditions of service and tenure of the office is determined by the president. See, even this is something which you should know because it is static part. Suppose even if you did not know or if you were unable to recall in the actual exam, how you could have thought of. See, State Election Commissioner, what does he do? He will conduct election to the local bodies. Means for Panchayat Raj institutions and for urban local bodies. The state legislature and the parliament elections will be done by the election commissioner, not the state election commissioner. So SEC, State Election Commissioner, will do elections for these two bodies. Then appointment is done by the governor. Yes, appointment is done by the governor, correct. But conditions of service and tenure is determined. See, why would president? There are so many state election commissioners. There are state election commissioners for each of these states, and it becomes very difficult for president himself to get engaged in these sort of things. So president will take up functions which are very, very important. For example, president will determine the conditions of service and tenure of the UPSC members, but not of this SEC sort of things. So try to understand in this way. So it is actually the governor. So even if you have forgotten, you would have easily recalled. For example, even if I have to tell in other ways, for example, conditions of service and tenure of Supreme Court judges, it is determined by the parliament. Most important function, parliament togolutte. If I have to tell, most important functions, parliament togolutte. For example, service and tenure conditions of Supreme Court judges. But if it is of High Court judges, then president bartare. State Election Commissioner ಈ ತರ ಇನ್ನೂ lower post ಆದರೆ then governor will come. ಈ ತರನು ನೀವು ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು so that you don't get confused. So when you are studying also, when you study that the conditions of service and tenure of office of SEC is been determined by the governor, just think why it is not president, because president cannot do all these things. He has a certain period of time where he has to manage all those things. So rather than president, so this is what governor would do. ಈ ತರನು ಕೂಡ ನೀವು ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು. See, memory, like I am telling, it will yellow on kade kai kodutte memory. Actual exam time there is so much of stress, there is limited time. So ee tara when you think in your mind, when you try to build that algorithm, easily you answer ಮಾಡಬಹುದು. Even if you are unable to revise just few days before the exam, ee tara ನೀವು trick work use ಮಾಡ್ಕೊಂಡು ನೀವು ಜ್ಞಾಪಕ ಮಾಡ್ಕೊಂಡ್ರೆ ಅದು helpful ಆಗುತ್ತೆ. So let us move forward. Judge of High Court appointed, removed. So this you should know. See, question on PIL, simple. See here, court fee for filing a PIL is waived off. However, if the petition is found to be frivolous, then fine is 50,000. Now, look at this. PIL itself, filing of PIL itself will take 50 rupees, and if it is found to be frivolous, then it is telling 50,000. So which is a very large number, which is wrong. Actually, there is no fine for filing frivolous PILs. That is one of the issue, and because of it, each and everyone who wants to file PIL, they are going in filing, and the court is bombarded with so much of PILs. Actually, this is one of the change that needs to be brought. See, Serious Fraud Investigation Agency, I leave it to you. State legislature have the power to carry out which of how many of the following functions. So here I found some sort of application of mine, and that is why I want to talk about this question. Making laws for prescribing punishment for practice of untouchability. Practice of untouchability, what is that? Its prohibition is under Article 17. Prescribing residence as a condition for certain employment. Article 23. It comes under Article 23. Prescribing punishment for trafficking in human beings, which is Article 24. Empowering courts other than the Supreme Court and High Court to issue directions. Okay, see, state legislature can empower courts other than Supreme Court and High Court to issue directions, orders and writs. Writs is as of now issued only by Supreme Court and High Court. It is telling state legislature can empower other courts, which is completely wrong. It is only the Parliament. As of now, Parliament has given the power to issue writs for Supreme Court and High Court. Parliament can give it even to other courts such as subordinate courts, but as of now, Parliament has not given that power to subordinate courts, and it is only the Parliament and state legislature cannot do the same. So, E Murna Nodi, Article 17, Article 23, Article 24. There is another article which is, I think, Article 33, 34, 35. I think it is Article 33 or 34, which I am not able to recall, which explicitly tells that any changes need to be made to the fundamental rights, then that power is only with the Parliament and not with the state legislature. So, it's application oriented question. Okay, we'll move ahead. See, how many of the following are features of state administrative tribunal? Simple question, I'll leave it to you. See, administrative tribunal, central administrative tribunal, state administrative tribunal, 42nd amendment, article 323A, 323B, ಇವೆಲ್ಲ ನೀವೇ ಓದ್ಕೊಬೇಕು. It is very clearly mentioned in Lakshmikant. See, following statements regarding Election Commission of India. Okay, here I think aspirants might have made a mistake. See, Election Commission of India has the power to sue candidates in case of non-compliance to Model Code of Conduct. Now, in this question, if you think too much, then you will get confused. If you think less, then you will get this question as correct. See, it has the power to sue candidates in case of non-compliance to MCC. You know that Model Code of Conduct is non-binding. It is non-justiciable. See, non-binding would be wrong. Model Code of Conduct is non-enforceable. That means you cannot enforce it. It does not have a statutory or law backing. So it is more of a voluntary code. But if you have studied much, or if you have come across current affairs, then you might have studied that important high profile personalities such as Maneka Gandhi, she was being debarred, she was being temporarily suspended to participate in the election campaign because she had violated MCC, Model Code of Conduct. So illi sue anna word kelada confusion agಬಹುದು. See, sue here means arrest. Election Commission can temporarily ban a person. Election Commission can issue notice or memos for violating Model Code of Conduct, but it cannot arrest the person. So here sue in that sense is arrest. So in that sense this will be wrong, and rest of the things is easy and you can manage. See, once in a while, every 2 to 3 years, UPSC will come up with such questions and ask you to guess which is the right option. So that is why I wanted you to be aware of these things. Who among the following decides the appointment of directors for board of PSUs? So PSUs, public sector units, we know it. So who appoints the directors for it? Ministry of Personnel, this we could have eliminated, this we could have eliminated. So confusion among these two, answer is Cabinet Appointments Committee. Now this is a very, very important committee when it comes to most of the appointments. So most of the appointments ke e committee ne barate. For example, even RBI governor post or deputy governor of RBI. There are so many committees which will make advisory or suggestions to cabinet committee on appointments, but it is this committee which will approve, and this is headed by Prime Minister. So Adariti, just think of other bodies. For example, if there are executive directors, if there are directors, if there are chairpersons which needs to be appointed for financial institutions, then there is another body which is FSIB, Financial Services Institutions Board. Munche BBB, Bank Board Bureau anta ittu. Then they abolished this. Then they set up FSIB, and this shall appoint important persons such as chairmen, directors, and so on for financial bodies. Financial bodies in the sense for banks, for PF, RDF, for pension bodies, for insurance bodies, and so on. So Itara try to link similar things and revise while you are studying. Now, National Research Foundation, this is important because National Research Foundation will be active only from 2023 to 2028. So adike just have a brief knowledge about what this is and what does it want to do. Apex body which wants to promote scientific education in accordance with NEP, correct? Union Minister of Science and Technology will be ex officio president. So, ee tara bandaga, see, whenever they are putting in some fact, please be extra careful. National Research Foundation, it is been headed by the Prime Minister. Minister of Science and Tech is the Vice President or the Vice Chairman of this body and not the Chairman. Make a note of it. So, that is why I marked it with purple. In this sort of facts or in this way, they try to give some traps. Aims to create interface mechanism for participation, contribution. See, these are generic statements. These tend to be correct. Idರಲ್ಲಿ ಏನೋ ಡೌಟೇ ಇಲ್ಲ. ಆದರೆ ಈ ವರ್ಡ್ ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು. And please read and go about NRF because this could be asked because this is an important upcoming body. So questions on such bodies have not yet been framed. Bharat Ratna, you would know about it. One or two basic things which I want to tell about Bharat Ratna. See, every year up to 3 persons can be given Bharat Ratna award, but last time that has been not been followed. 5 persons were given Bharat Ratna award. Other than M.N. Swaminathan, there were 4 other ex-politicians who were given the award. So 5 persons were given. Bharat Ratna dalli there is no monetary grant or no monetary benefit that is been given. And usually Bharat Ratna is been given even when the person is not been alive. There are so many persons who after their death, their family members got Bharat Ratna. So adanne avaru posthumously anta helidare. It cannot be awarded. See, ನಿಮ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ನೆಗೆಟಿವ್ ಆಗಿ ತಗೊಂಡಿದ್ರೆ it cannot be awarded. ನೆಗೆಟಿವ್ ಆಗಿ ತಗೊಂಡಿದ್ರೆ you would have got this as correct. Year not sure, could be a wrong fact. Recipients are honored with a certificate signed by Prime Minister. See, who is the important office when it comes to all these sort of things? It is the President, not the Prime Minister. Because Prime Minister, it is not a constitutional office. Rather, Prime Minister is that party thing. So, idunna kuda wrong ತಗೊಂಬೋದಿತ್ತು. There is no monetary grant associated with the award. This is the only thing that is correct. Sangeet Natak Academy, I'll skip this question. How many of the above acts are administered by DPIIT? See, DPIIT another important body which is under Ministry of Commerce and Industry. So, there are certain acts on which DPIIT has the power to exercise. For example, yadado DPIIT, what does it do? Basically, patent or the intellectual property rights na protect mada kelsa DPIIT. So, DPIIT copyrights, patents, GI, trademarks, similar things. So, DPIIT will protect these things. But what about the other thing? See, if you knew what DPIIT is, if you had studied that it falls under Commerce Ministry and you had studied these acts, then you should be aware that 2, 3, 4, 5 pakka barate under DPIIT. Your only confusion is whether the Explosives Act would come under DPIIT or not. So, your only confusion should have been for choosing between 4 and all 5. Your confusion should not be only 2 or only 3. Simple. But look at this, industry and internal trade. Take a broader picture of this industry and internal trade. So industries, they could be such industries also, explosives industry, boilers, inflammable materials. So Boilers Act, Inflammable Materials Act, Explosives Act, even they are administered under DPIIT. So ee tara broad agi think madabeku. So answer to this question is all 5. Even if you are confused with the first statement, your only confusion should have been between choosing only 4 or only 5. Consider the following statements about the roster system in Supreme Court. Sole decision making authority to decide the procedure and practices to be followed. See, whenever these terms like sole, only, you should become extra careful. Sole decision making authority to decide the procedure and practices. See, when we decide procedure and practices, there is a lot of discussion and lot of brainstorming that needs to be done as to what needs to be followed and what not needs to be followed. So Supreme Court does it alone. Supreme Court actually does it in consultation with the president, because president means that indirectly the cabinet will be involved. So Supreme Court does not do it alone. Supreme Court does it with in consultation with the president. Now this is mentioned in Lakshmikant and we need to recall these things. Roster system of allocation of cases is based on convention. See, idu nimage confusion ಆದರೆ just recall roster system ಅನ್ನೋದು ಇದೆ ಗೊತ್ತಿದೆ. Roster system, is it been backed by any constitution article that we recall of? No. Have we come across any law which promotes a roster system? No. If these two things, if you studied very well and neither the constitution article nor any law is coming to your mind when it comes to this roster system, then you could have taken it as convention, which indeed is correct. CJI is the master of roster, yes, and he has sole discretion in deciding the benches and assigning cases. See, when it comes to assigning cases and all, though here sole is there, when we are assigning cases, we want it to happen very quickly and we cannot involve multiple persons to create conflict in assigning cases. So this responsibility has only been given to CJI. So ee tara think ಮಾಡಿ ಇದನ್ನ ಗೊತ್ತಿದ್ರೆ ಇದು ಕರೆಕ್ಟ್ ಅಂತ ತಗೊಂಬೋದಿತ್ತು. So in that case, this would have been wrong. Answer is only 2 and 3. See, I am telling these things just to ensure that in case if you forget in the exam, if you get confused whether procedure and practices is solely by CJI or whether assigning cases is solely by CJI. So in that cases, ನಾನೀಗ ಯಾವ ಥರ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದೆ ಆ ಥರ ಜ್ಞಾಪಕ ಇದ್ರೆ ಈಸಿಲಿ ಡೆಡ್ಯೂಸ್ ಮಾಡ್ಬೋದು. But these things are explicitly mentioned in Lakshmikant. If you have a very good memory, then you can easily recall these statements. But in case memory ಕೈ ಕೊಡ್ತು ಅಂದ್ರೆ ಈ ತರ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದ್ರಿಂದ you can easily come to the right answer. Central Administrative Tribunal, simple thing, I'll leave it to you. President can remove UPSC members without consultation. See here, even if you did not know or not sure of this question, how you can have deduced it. President can remove the UPSC members without consultation. See, usually president should remove UPSC members in consultation with Supreme Court, but without consultation also he can remove on grounds of what? See, infirmity of mind and body, adjudges insolvent, misbehavior, paid employment outside the duties. Now this anyone would know that paid employment outside the duties of office, then president can remove that member. And these two also are very technical terms if you see. But when it comes to misbehavior, how do you define misbehavior? There is no proper definition of misbehavior. So in ನಾಲ್ಕು statement ಅಲ್ಲಿ ನೋಡಿದ್ರೆ misbehavior ಅನ್ನೋದು it is very subtle. The president on the advice of the cabinet could even over exercise their power if it is on misbehavior, because misbehavior itself has not been defined. So even a small thing which is not that big of a misbehavior, even that could be used to target certain people from UPSC by the government or the cabinet members through president. So ee tara agbardu andre, just to prevent it, this power has not been given to the president. So if there is cases of misbehavior, then the president has to refer the case to the Supreme Court, and Supreme Court will do an inquiry, and based on that Supreme Court will tell whether it is a case of misbehavior or not. So ಈ ತರ ನೋಡಿದಾಗ ಈಸಿಲಿ ಅರ್ಥ ಆಗಬೇಕು which is the wrong option or which is that option which we can pakka tell among these that this is wrong. So here that case is misbehavior. So misbehavior na eliminate ಮಾಡಿದ್ರೆ 3 gone, answer ಸಿಕ್ತಿತ್ತು. So you could have deduced this. So when you read the question and see the options, do not get nervous. See which option tend to be the more negative one or the more wrong one, and take that option to be wrong and then see the options. We'll move ahead. How many of the following subjects are mentioned in 11th schedule? Now this is a simple question. 11th schedule there are 29 subjects I suppose, and in 12th schedule there are that 16 or something subjects, and which are those subjects we will have a broad idea, but it may be hard for us to remember all those subjects. So ade in these cases, instead of rote learning, instead of complete memorization, try to understand take each of those subjects. When you read each of those subjects, think why it is under PRI, why it is under Panchayat Raj, why these subjects are under urban local bodies, why not under PRI, why not under ULB. ಇದನ್ನೇ ಮಾಡಬೇಕು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಇದರಲ್ಲಿ ಸಿ 11th schedule Panchayat Raj institutions. So anything that is related to rural thing, that will be given to PRI. Anything related to urban thing will be given to ULB. Simple thing. So non-conventional energy sources, non-conventional ಅಂದ್ರೆ solar. PM ಕುಸುಮ್ ತಲೆಗೆ ಬಂದ್ರೆ ಸಾಕು, ದಟ್ PM ಕುಸುಮ್ ಫಾರ್ಮ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಸೆಟಪ್ ಮಾಡ್ತೀವಿ ಅಂತ, ಇದನ್ನ ನೀವು ಕರೆಕ್ಟ್ ತಗೊಂಡ್ಬಿಡ್ತಿದ್ರಿ, ಸರಿನಾ? ಟೆಕ್ನಿಕಲ್ ಟ್ರೈನಿಂಗ್ ಅಂಡ್ ವೊಕೇಶನಲ್ ಟ್ರೈನಿಂಗ್. ವೊಕೇಶನಲ್ ಟ್ರೈನಿಂಗ್ ಇಸ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ವಿಚ್ ಇಸ್ when it comes to rural areas. ಇದನ್ನು ಕರೆಕ್ಟ್ ತಗೊಂತೀರಿ. ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್. ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಅರ್ಬನ್ ಅಲ್ಲೂ ಇಂಪಾರ್ಟೆಂಟ್, ರೂರಲ್ ಅಲ್ಲೂ ಇಂಪಾರ್ಟೆಂಟ್. ರೂರಲ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ಜಾಸ್ತಿ ಇಂಪಾರ್ಟೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಮೈನರ್ ಫಾರೆಸ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್, ವಿಚ್ ಇಸ್ ರಿಲೇಟೆಡ್ ಟು ದ ರೂರಲ್ ಥಿಂಗ್. ಸೊ ಇದೀಸ್ ಗೊತ್ತಿದೆ. ಸ್ಲಮ್ ಡೆವಲಪ್ಮೆಂಟ್. There are no slums. Slums are a terms used when it comes to urban localities. So 4 na eliminate ಮಾಡಿದ್ರು, 4 na eliminate ಮಾಡಬೇಕಿತ್ತು. 1, 2, 3 and 5 are the answer. So in this way also you can deduce. See, even I don't remember each of those 29 lists which are mentioned in the 11th schedule. So this is where the difference between prelims and mains come in. Mains alli in the 29 at least 6 or 7 we should have remembered and we should have written in the exam. But here answer is in front of you. Even if you play that detective role game, you can easily see which is the most wrong one, just like I spoke in the previous question. So we'll move ahead. Till date, President has established 3 commissions as per Article 340 to study situation of backward classes. Okay, we'll see it later. India maintains dual system of OBC list, central list and individual list for state. Karnataka people, you should be very aware that state has a different list. So category 1, 2A, 2B, 3A, 3B, this is for the Karnataka state. Such categorization does not exist at the central level because we have dual system. So istu gottidru no, all those who have claimed reservation at least should know this. All those people from Karnataka should know this, and there was no way you should have got this wrong. If you got this wrong, then that means that thinking al ಸ್ವಲ್ಪ issue ಆಗ್ತಾ ಇದೆ. To date, no state government in India has subcategorized. See, no state government, it itself is telling. Nam state ಮಾಡಿದೆ category 1A, 2A, 2B anta. So this is wrong. So many states have subcategorized. Just that at the central level, there is no subcategorization. In the sense, if you are availing reservation services, if you are availing reservation benefits for central government jobs, then there is a broad categorization that you are OBC. There is no 2A, 2B in the central level or another categorization that category 1, category 2, category 3. ಈ ತರ ಏನು ಸಬ್ ಕ್ಯಾಟಗರೈಸೇಷನ್ ಆಗಿಲ್ಲ. ಈ ತರ ಸಬ್ ಕ್ಯಾಟಗರೈಸೇಷನ್ ಸೆಂಟ್ರಲ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತಾನೆ ರೀಸೆಂಟ್ಲಿ ಇನ್ ದ ಇಯರ್ 2017 ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಡ್ ಅಪಾಯಿಂಟೆಡ್ ಅ ಕಮಿಟಿ ಆಫ್ ಜಸ್ಟಿಸ್ ರೋಹಿಣಿ. So that is what. Now this is correct, this is wrong. So we'll see the options. 3 is wrong and 2 is correct. So either A or C madhya ತಗೋಬೇಕಿತ್ತು options. In case if you did not know this, President has established 3 commissions under Article 340, under Article 340 to study situation of backward classes. See, we should know this fact of Article 340 and we should also know about these 3 commissions. Which are those 3 commissions? One is Kalekar ಕಮಿಷನ್ ಫಸ್ಟ್ಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದು in 1950s. After that came Mandal, and it was through this Mandal commission that OBCs got reservation. And the recent one was Justice Rohini Committee, and Justice Rohini Committee was for subcategorization of OBCs. It has not yet been implemented, because if that is been implemented, then those who are at the bottom, they might get better benefits among the OBCs. So 3 commissions, and this commission appointment is been done by the president under Article 340. And which are those 3 commissions? Idish ಗೊತ್ತಿರಬೇಕು. Consider the following statements: arbitration, decision making. See, now what is arbitration, mediation, conciliation, negotiation? You should know. Just I want to tell in this how to remember. I myself used to get confused between conciliation and mediation. So ಹೇಗೆ ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು? ಸಿ ABCD A to Z ಆರ್ಡರ್, ಅದೇ ಆರ್ಡರ್ ಹೋಗಿ ಎ ಆದ್ಮೇಲೆ ಸಿ ಬರುತ್ತೆ, ಸಿ ಆದ್ಮೇಲೆ ಎಂ ಬರುತ್ತೆ, ಎಂ ಆದ್ಮೇಲೆ ಎನ್ ಬರುತ್ತೆ. ಸೊ ಇನ್ ದಿಸ್ ವೇ, ಸಿ ಪವರ್ is actually decreasing, or you can say power is increasing in this way. Negotiation alli there are 2 members who will communicate, who will discuss and sort out the issue. Mediation alli there is a 3rd member who will make these 2 members talk to each other and come at a solution. So in mediation, the person is neutral, he is not very active, he is a passive personality. In conciliation, the 3rd person is active, he will suggest solutions, he will bring about the resolution among these other 2 parties. In arbitration, the 3rd party or the court or the tribunal will give a binding decision. So whatever decision it gives, the other two parties have to follow it. So usually now any court, high court, supreme court, subordinate court, it is all arbitration. Conciliation, mediation, negotiation, even these are alternative dispute resolution mechanisms. So idra ಬಗ್ಗೆ ಗೊತ್ತಿರಲಿ basics. So ನಾನು ಇದು ಹೇಳಿದ್ದೇನೆ ಯಾಕಂದ್ರೆ in case if you get confused which is which, just remember ABCD order. Central Social Welfare Board, if you do not know about this, then it was better meant to be left, because Central Welfare Board, it is for woman child and not construction workers. Because ಇದನ್ನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಕರೆಕ್ಟ್ ತಗೊಂಡಿದ್ರೆ ಇದನ್ನು ನಾವು ಕರೆಕ್ಟ್ ತಗೊಂತಿದ್ವಿ ಸೋಷಿಯಲ್ ಜಸ್ಟಿಸ್ ಮಿನಿಸ್ಟ್ರಿ ಅಂತ. ಬಟ್ ಇಫ್ ವಿ ನ್ಯೂ ಸೋಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಬೋರ್ಡ್ ವಾಸ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ವುಮನ್ ಅಂಡ್ ಚಿಲ್ಡ್ರನ್, then we would have understood that it comes under Ministry of Women and Child Welfare. And this is not that important body, so I'll leave it to you. ಇದು ಅಷ್ಟೇ ಸೈನ್ಸ್ ಅಂಡ್ ಇಂಜಿನಿಯರಿಂಗ್ ರಿಸರ್ಚ್ ಬಾಡಿ. I'll skip. Constitutional Amendment 1976, 42nd Amendment, you should know. I'll skip this question. See, dying declaration. Now this is not something that we would have come across, but we'll see. If we did not know much about dying declaration, how we could have got the question as correct. Dying declaration ಏನು ಅರ್ಥ ಆಗ್ತಾ ಇದೆ? There is some declaration that is made by a person when he is dying. Last few words. It is dealt under Bharatiya Sakshya Adhiniyam. It is a replacement of Indian Evidence Act. ನಾವು ಇಷ್ಟರೂ ಗೊತ್ತಿರಬೇಕು, ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತ, BNHS, ಸೊ ಇವೆಲ್ಲ ಏನು ಅನ್ನೋದು ಗೊತ್ತಿರಬೇಕು. ಸೊ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್, ಸೊ it is dealt under Bharatiya Sakshya Samvida, means dying declaration is taken as evidence is what it is telling. Okay, it is admissible as evidence in proceedings of civil and criminal. So criminal we would have taken it as correct, civil we might get confused. Okay, there is no specific format required for a dying declaration. See, a person who is dying, we do not expect him to write in some letter or write in formals or make that person type something. When he is dying, all we want is, we just want to listen to the person in whatever format it is. So there is no specific format. This you should have thought it to be correct. It can only be recorded by SI. So last moment when he is dying, we do not expect a particular person to come there and record. Anybody could record it. So this is wrong. So 4 is wrong, 3 is wrong. It is admissible as evidence. See, when a person is dying, now that person could tell some important thing which he wanted to tell earlier but was not able to. Or even if he wants his property to be divided among so and so kins of him, then he could give the declaration. So ಆ ಥರ ನಾವು ಥಿಂಕ್ ಮಾಡಿದರೆ ಸಿವಿಲ್ ಕೇಸ್ when it comes to property as well as criminal case, ಇವೆರಡನ್ನೂ ಕರೆಕ್ಟ್ ತೊಗೊಂತಿದ್ವಿ. ಆ್ಯಂಡ್ ಇವೆರಡನ್ನೂ ಕರೆಕ್ಟ್ ತೊಗೊಂಡ್ವಿ ಅಂದರೆ ಇಟ್ ಈಸ್ ಅ ಎವಿಡೆನ್ಸ್. So we are considering it as evidence. So if it is evidence, then it will come under this. It is dealt under BSA only because it is a replacement of IEA. ಸೊ ಈ ತರನೂ ಇದನ್ನ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಬೋದಿತ್ತು. ಸೊ ಮೇನ್ ಥಿಂಗ್ ಇದು ಕರೆಕ್ಟ್ ಇದು ರಾಂಗ್ ಅಂತ ತಗೊಬೇಕಿತ್ತು. ದೀಸ್ ಟು ಎನಿವೇ ದೇ ಗೋ ಹ್ಯಾಂಡ್ ಇನ್ ಹ್ಯಾಂಡ್. ಸೊ ಕನ್ಫ್ಯೂಷನ್ ಇನ್ ಕೇಸ್ ಆಗಿದ್ರು ಕನ್ಫ್ಯೂಷನ್ ಶುಡ್ ಹ್ಯಾವ್ ಬೀನ್ ಬಿಟ್ವೀನ್ ಓನ್ಲಿ 1 and only 3 and not others. In case if you have studied about this, it's good, but I don't hope that you would have come across this dying declaration thing. So statements in the ಏನೋ ನಾವು ಡೆಡ್ಯೂಸ್ ಮಾಡಿ ಅಟೆಂಪ್ಟ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಸೊ ಐ ಆಮ್ ಟೀಚಿಂಗ್ ಯು ಸರ್ಟನ್ ಟ್ರಿಕ್ಸ್. ಸೊ cantonment and leave it to you. Which of the following parts of Constitution of India ensures gender equality? Now you should know this. See, gender equality, just I'll tell in brief. Now this is sort of application based of question. 2021 UPSC paper ನೋಡಿ ಈ ತರ ತುಂಬಾ questions ಬಂದಿದೆ. So which of the following parts ensures gender equality? It is not just a general equality, it is gender equality. Okay. So fundamental rights, yes. Article 15, Article 14. DPSP, yes. Article 39, equal pay for men and women, yes. Fundamental duties, yes. Do not practice derogatory practices to women. So ಈ ಮೂರು ಕವರ್ ಮಾಡುತ್ತೆ. 8th schedule, you see what it is related to official languages. The official languages has nothing related to gender. So answer is 2, 3, 4. Just I spoke about this question because DPSP and FD, fundamental duties, it is very implicitly mentioned about gender equality. So if you're not able to recall the articles of DPSP as well as fundamental duties, then you may not think about it. ಅದಕ್ಕೆ ನಾನು ಈ ಕ್ವಶನ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದು. ಸಿ ಅದೇ whenever questions are asked on fundamental rights, DPSP, fundamental duties, you need to recall the provisions of each of those articles and then you need to think whether it is correct or wrong. For example, ಇದೇ question, for example, which of the following articles deals with the welfare of SC, ST or welfare of tribals ಅಂತ ಕೇಳಿದ್ರೆ ಅವಾಗ ಆರ್ಟಿಕಲ್ಸ್ ನ ರೀಕಾಲ್ ಮಾಡ್ಕೊಬೇಕು. ಆರ್ಟಿಕಲ್ 46 providing affirmative action to SC, ST. So ಈ ತರ ಆರ್ಟಿಕಲ್ಸ್ ಇಂದ yes DPSP does support to uplift the vulnerables such as SC, ST ಈ ತರ ಥಿಂಕ್ ಮಾಡಬೇಕಾದ್ರೆ. ಸೊ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್, ಫಂಡಮೆಂಟಲ್ ಡ್ಯೂಟೀಸ್ ಅಂಡ್ DPSP ಬಯಾಟ್ ಇದ್ದಷ್ಟು ಒಳ್ಳೆಯದು. ಮೇನ್ಸ್ ಅಲ್ಲೂ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ, ಪ್ರಿಲಿಮ್ಸ್ ಅಲ್ಲೂ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ. Now this is simple thing. Only fundamental rights fall under the category of justiciable rights under the Indian Constitution. Do not confuse here. Constitution is very broad. Fundamental rights, DPSP, fundamental duties bitti kuda eston vishayagulu ide. So only fundamental rights is justiciable rights. See, among DPSP fundamental right is justiciable. But when we consider Constitution as a whole, there are so many rights which are justiciable. Article 300A, Article 326, 300A right to property, it is justiciable. Just that Article 300A, it is justiciable, but it is not a fundamental right. Means if someone is been deprived of the right, he cannot directly approach the Supreme Court or the High Court. He will have to first go to subordinate court, then High Court, and then Supreme Court. But justiciable means not just Supreme Court or High Court. Justiciable means he could go to any court for the realization of the rights. Article 300A, Article 326, ಇವೆಲ್ಲ justiciable rights. So Constitution ಎಷ್ಟೊಂದು justiciable rights ಇದೆ, other from fundamental rights also. ಇದು ಗೊತ್ತಿರಬೇಕು. I hope you do not get confused. If you get confused, that's what. Just think Constitution, what is it made of? Not just fundamental rights and DPSP, there are so many other rights. Part 4 of the Constitution. Okay, simple thing, I'll leave it to you. See here again, only the Parliament can make provisions related to regulation of cooperative societies. Whenever this term only comes, be extra careful. Only the Parliament can make provisions related to cooperative societies. No, the state government can make. And even if you remember this thing called Registrar General of Cooperative Societies or State Registrar of Cooperative Society, State Registrar of Cooperative Societies. Even if you recall this thing, you would have known that it is not just the Parliament. In fact, Parliament doesn't regulate cooperative societies. Parliament regulates interstate cooperative societies, because when it's interstate, sometimes the states and states, due to different governments, due to different ruling party governments, they may not agree or synchronize their decisions. So that is when the Parliament would need to step in. So ಯಾವಾಗಲೇ interstate river regulation ಆಗಲಿ, interstate cooperative societies ಆಗಲಿ, interstate ಅನ್ನೋ ಟರ್ಮ್ ಬಂದಾಗ ಪಾರ್ಲಿಮೆಂಟ್ ಬರುತ್ತೆ. Within the state ಅಂತಿದ್ದಾಗ it is under state government only. Right to form cooperative society, it is a fundamental right. It is a fundamental right under Article 19, 19(1)(c). ಸಿ 19(1)(a), 19(1)(b), 19(1)(c), 19(1)(d), 19(1)(e) ಬಯಾಟ್ ಇರಬೇಕು. 19(1)(c) means right to form association. Cooperative society is a form of association. So it is a fundamental right, and also it is found under DPSP under Article 43B. ನೋಡಿ ಇವೆಲ್ಲ ಬಯಾಟ್ ಇರಬೇಕು. ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟು ನಾವು ಡೀಲ್ ಮಾಡಾಯಿತು. The audit report of accounts of an apex cooperative society shall be laid before the state legislature. This is important, you should know. Audit report of accounts of apex important cooperative societies ಯಾವ್ದು ಇರುತ್ತೆ, ಎಲ್ಲ cooperative societies report na auditor state legislature ಇಡಕ್ಕಾಗಲ್ಲ, but which is very important. These audit reports needs to be laid before the state government because we want to keep a check over it. Now this was something which I wanted you to make a note of. Even if you do not note it in your notes, it's fine because it is not that important of a fact, but cooperative society topic is important. So when you come across that, at least one recall ಮಾಡ್ಕೊಳ್ಳೋ ಎಬಿಲಿಟಿ ಇದ್ರೆ ಸಾಕು, ದಟ್ ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಚರ್ ಮುಂದೆ ರಿಪೋರ್ಟ್ ನ ಇಡ್ತಾರೆ, ಓಕೆ ಅಂತ. So again, with reference to delegation of functions of between center and state, now this is directly mentioned in Lakshmikant. The only thing is you might get confused, that is why I wanted to talk about this. Center can delegate both legislative executive powers. See, center cannot delegate legislative power. Mutual delegation of administrative function may be conditional, unconditional, correct. President can delegate executive functions to the states without the latter consent. See, here there is a difference. If the state governments are not agreeing, still the executive functions of the center can be delegated only if it is done by the parliament. If it is done by the president, then it means that then it has to be with the latter consent, means with the consent of the state. So president madre state's consent beku, parliament madre state's consent bada. So when it comes to delegation, here also parliament has more power compared to the state legislature. State legislature may with the consent of the central government delegate to them any of the governor functions. See, ಮತ್ತೆ change ಮಾಡೋದು, it is not state legislature, it is the governor. See, ಇಲ್ಲಿ president ಬಂದಾಗ state legislature ಬರುತ್ತೆ, ಇಲ್ಲಿ governor ಬಂದಾಗ parliament ಬರುತ್ತೆ. It is not state government, central government or governor parliament, governor president. It is state legislature, president or governor parliament. So ಈ ತರ ಬರುತ್ತೆ. With respect to appointments of judges in high court, simple question, I leave it to you. Person can be disqualified from contesting the election in parliament. Okay, see, even in this question we would not have come across National Honor Act of 1971. Even if we have come across, we would have forgotten by then. So how we could have deduced the question? What are the most important things? We'll try to focus on that. See, one is national flag, constitution, national anthem, national flag, national animal. Most important thing ನಮ್ಮ ತಲೆಗೆ ಏನು ಬರುತ್ತೆ? Yes, constitution ನ ಮಾಡಿದ್ರೆ yes. Second most important thing ನಮ್ಮ ತಲೆಗೆ ಬರೋದು national anthem. National anthem, national flag ಕೂಡ ಬರುತ್ತೆ. National flag, constitution first ತಲೆಗೆ ಬರಬೇಕು. Even if anthem is not there, it's fine. See, killing the national animal or bird, this is something ಯಾಕೋ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟ್ರಾ ಸೇರಿಸಿದಾಗೆ ಇದೆ ಕ್ವಶನ್ ಅಲ್ಲಿ. ಸೊ 2 ಮತ್ತೆ 5 ನ ಇಟ್ಕೊಂಡು ಡೆಡ್ಯೂಸ್ ಮಾಡಿ. 2 ಮತ್ತೆ 5 ಇರಬೇಕು, 2 ಮತ್ತೆ 5 ಇರಬೇಕು. ಸೊ 2 3 5 3 ನೋಡಿ national anthem, which we can agree, but so we'll have to choose between these two. So you have to take a guess between these two. Killing the national anthem, national animal or bird. Now that is prevention of insults to national honor. Now this is too much, like, because national animal, national bird, peacock dalla ಎಷ್ಟೊಂದು ಸತಿ ಡೆತ್ ಆಗತ್ತೆ, people kill it, ಈ ತರದೆಲ್ಲ we would have come across. So this would not have been covered ಅಂತ ನಾವು ಅನ್ಕೊಂಡಿದ್ರೆ we would have come to the answer 2 3 5. Consider the following statements with respect to Lokpal, Lokayukta. I leave it to you. FIR. See, things about FIR. See, this FIR and these sort of things, FIR, dying declaration, bails, these are governance sort of questions. This we would have not have come across while studying in Lakshmikant, because even in Lakshmikant you would have come at the last few pages. So ಈ ತರ ಬಂದಾಗ ಯೂಶುವಲಿ ಗವರ್ನೆನ್ಸ್ ತುಂಬಾ ಕ್ವಶನ್ ಬರಲ್ಲ, ಆದರೆ ಬಂದ್ರೆ ಈ ತರ ಅಟೆಂಪ್ಟ್ ಮಾಡಬೇಕು. ಐದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ನಾವು ಟ್ರ್ಯಾಪ್ ಕೊಡ್ತಾರೆ ಅಥವಾ ಒಂದು ಸ್ಮಾರ್ಟ್ ಗೆಸ್ ವರ್ಕ್ ಇಂದಾನೆ ಅಟೆಂಪ್ಟ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಸೊ ವಿಲ್ ಹ್ಯಾವ್ ಬೇಸಿಕ್ ನಾಲೆಜ್. FIR cannot be filed for non-cognizable offense. So what is cognizable and non-cognizable offense? I hope it's visible. See, cognizable offense. Cognizable offense means you can arrest without warrant. So warrant na ellinda tartare, warrant na court inda tartare. See, certain offenses, they are more harmful, they are more dangerous. So those offenses, when they have been committed, they are considered as cognizable offenses. So cognizable offense adaga, the police officer can arrest even without a warrant. So in such cases, they can investigate even when court has not given them the warrant. Cognizable offense adaga. Here they are talking about non-cognizable offenses. So when non-cognizable offenses are being done, then before investigating or before arresting the person or the accused, the police will need the warrant from the court. So FIR cannot be filed by the police for non-cognizable offense without the permission of the court. This is correct. FIR must be documented in writing by the responding police officer, regardless of whether the complaint is made morally. See, FIR, first investigation report, and it is a written report. So orally accused or the eyewitnesses, whether they tell it orally or whether they give it in writing, the FIR will have to be written in writing. Idu gottirbeku. Accused is entitled to obtain a copy of FIR filed against him or her. Neevu heli. Now this is a basic right, and you should take it as correct. Accused is entitled to obtain a copy of FIR filed against him or her. Correct. So this is correct. This is correct. Now these two anyway would have thought of. The only thing is whether this, because cognizable, non-cognizable confusion is statement 1 madhya confusion barate. So confusion should have been between 2 and 3. With regard to powers and jurisdiction of Supreme Court of India, election petition regarding vice presidential and presidential. See, the only thing which I wanted to tell is, see, when there are disputes with regarding to MLA or MP election, then the dispute needs to be taken to High Court at the first instance. And the original jurisdiction of High Court under barate. When there are disputes with regard to elections of president or vice president, then it is taken to Supreme Court directly, not High Court. So petitions regarding presidential and vice presidential filed directly in Supreme Court. This is correct. This you should know. And rest of the things are simply 10% to conduct and behavior of members of chairman UPSC on a reference made by the. Okay, this is correct. It has power to review its own judgment. See, Supreme Court has a power to review its own judgment. This is correct. But does High Court have? In normal books and test series that we study, it has been mentioned that High Court has the power to review its own judgment. But check this thing in UPSC answer key and you yourself tell me whether it is correct or wrong. Because UPSC again had come with a controversial answer key over this sentence. Contempt of court, simple thing, I'll leave it to you. Doctrine of severability. See, there are so many doctrines and we cannot remember each of these. If we remember any 2-3 important doctrines, we can quote it in a mains answer. But this is one thing which I wanted you to make a note of. Doctrine of severability means doctrine of separation. So when a certain law has been made, there might be certain provisions which are unconstitutional or against rule of law, and there are certain provisions which are considered okay, which are considered to be formidable with the existing provisions. So in that case, what do we do? What does the court do? It will strike down certain provisions which are going against the constitution, and it will keep the provisions which are in sync with the constitution. So only the constitutional part of a law, only the unconstitutional part is struck down and not the entire law. This is correct. So doctrine of severability or separability means this thing. For example, even in Aadhaar Act, there were certain provisions of Aadhaar Act 2016 which have been struck down and certain parts were been retained. So how was this done? This was done by using doctrine of severability. So Aadhaar Act alli Supreme Court has upheld that it is mandatory to get benefits, avail benefits from the state, such as PDS and so on. But certain things like linking of SIM card with the bank account and these things have not been made mandatory by the Supreme Court. It has struck down certain provisions, but it has kept certain provisions of Aadhaar Act. That is under this doctrine. So ತುಂಬಾ ಬೇಡ, ಮೇನ್ ಡಾಕ್ಟ್ರಿನ್ ಏನಂತ ಗೊತ್ತಿರೋ ಸಾಕಿದ್ರಲ್ಲಿ. ಫಂಡಮೆಂಟಲ್ ಫೀಚರ್ ಆಫ್ ಫೆಡರಲ್ ಸ್ಟ್ರಕ್ಚರ್, ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಎಲಿಪ್ಸ್, ದಿಸ್ ಐ ಲಿವ್ ಇಟ್ ಟು ಯು. Constitutional anti-defection law, 52nd, you should know. Article 352, what are the grounds on which it is declared? Simple question. Attorney General. Okay, again Attorney General, Article 76. Second question on Attorney General. Shall receive such enumeration as the Parliament may determine. See, I told you that time. I told you one thing that time. What was that? I told you when it is this remuneration, terms of service, salary, all these things, when it is been involved, I told you that first comes Parliament, which will take most important things, after that President, and after that would come Governor. So ಅದೇ lens ಅಲ್ಲಿ ನೋಡಿ, he or she will receive such remuneration as the President may determine. It is not the Parliament. Parliament ಯಾವುದೋ ಒಂದು ಎರಡು ಮಾಡುತ್ತೆ ಅಷ್ಟೇ, ಲೈಕ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ ಎಕ್ಸೆಟ್ರಾ. ಅದು ಬಿಟ್ಟರೆ ಮಿಕ್ಕಿದೆಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಪ್ರೆಸಿಡೆಂಟೇ ಮಾಡೋದು. If it is some office which mainly works for the state government, such as SEC, State Election Commissioner, ಆ ಕೇಸಲ್ಲಿ ಮಾತ್ರ President would not be involved, it would be the Governor. See, he or she has the right to speak and all those things without the right to vote, correct? His or her term of office is fixed, I already told. There's no fixed office. Attorney General holds office during the pleasure of the President. See, I hope you know what is this holds office during the pleasure of the President. Pleasure of the President means the office does not have a legal backing of these many years. For example, Supreme Court member does not hold pleasure under the President because usually UPSC member would have a term of office of 5 years. But even if he is to be removed, the President cannot do it on his own suo moto, that too with discretionary power. He has to refer the case to the Supreme Court, and Supreme Court through inquiry, whatever it will tell, he should act on the binding advice of the Supreme Court. So UPSC member, Comptroller, Auditor General, Election Commission, these are more important officers, and these do not hold pleasure. These officers do not come under the pleasure of the President. But when it is Attorney General and these sort of officers, they hold pleasure under the President. So ಈ ತರ ಜ್ಞಾಪಕ ಮಾಡ್ಕೊಬೇಕು, ಯಾವ್ದನ್ ಜಾಸ್ತಿ ಇಂಪಾರ್ಟೆಂಟ್ ಆಫೀಸ್, ಯಾವ್ದನ್ ಕಡಿಮೆ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂತ ಮೈಂಡ್ ಅಲ್ಲಿ ಒಂದು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಬೇಕು. ಓಕೆ, SPSC, I leave it to you. Enforcement Directorate. See, it operates under Department of Revenue, Finance Ministry. I expect you to know. See, Finance Ministry ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಇದೆ, ಈಚ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂಡರ್ ಯಾವ ಈ ತರ ಬಾಡೀಸ್ ವರ್ಕ್ ಆಗುತ್ತೆ. Please make a note of it. ED can make arrest on violation of PMLA. Yes, even without mandatorily giving a copy of enforcement can information report to the accused. ಇದನ್ನು ಯೋಚನೆ ಮಾಡಬಹುದಿತ್ತು, because ED itself takes up cases which are very, very important, and in such heinous cases you do not expect them to give a copy of the report. See, ED, when it is arresting, at the time of the arrest, it need not tell to the accused about the grounds of arrest, but within 24 hours, Supreme Court has told, within 24 hours, ED is supposed to tell about the grounds of arrest to the accused. It is about the grounds of arrest, not the comprehensive report. So, answer C. National Commission on Scheduled Tribes, I'll leave it to you. You can have a look. See, NCSC, NCST, under what article is it formed? It was what amendment that made NCSC and NCST get bifurcated? ಇವೆಲ್ಲ ಗೊತ್ತಿರೋ ಸಾಕು. ಎಷ್ಟು ಜನ ಮೆಂಬರ್ಸ್ ಇರ್ತಾರೆ? This is not something that UPSC has gone for, because in each of these, who appoints them? Every time the committee of members changes, because with Prime Minister there would be other members who would be clubbed up, and also NCSC ಎಷ್ಟು ಜನ ಮೆಂಬರ್ ಇರ್ತಾರೆ, UPSC ಎಷ್ಟು ಜನ ಇರ್ತಾರೆ, NCST ಎಷ್ಟು ಜನ ಇರ್ತಾರೆ. This is not that important. UPSC Election Commission, okay, basic idea ಬೇಕು, but not NCSC and NCST. Even if you want to remember, it's left to you. With reference to function of Election Commission in India. Okay, we'll move to the next question. With reference to function of Election Commission of India. So, statements ಕೊಟ್ಟಿದ್ದಾರೆ, functions ಕೊಟ್ಟಿದ್ದಾರೆ. Which of the following are the functions of Election Commission of India? Exercise the authority to suspend polls in case of rigging. This Election Commission has done so many times. It is a simple thing. Provide its opinion, not binding thing, opinion to the governor when it comes to disqualification of members of state legislature. Yes, this is also correct. Register and deregister parties, we'll see. Register parties, yes. See, register parties, okay. But deregistering of political parties, this power has not yet been given to Election Commission of India, because political parties at the beginning, when they want to register, they follow all the protocols and so on thing. But there are issues with respect to political parties which is observed at a later stage. So deregistering of political parties, ಈ ಪವರ್ ಇನ್ನೂ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಆಫ್ ಇಂಡಿಯಾಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಐಡೆಂಟಿಫೈ ದ ಸೀಟ್ಸ್ ಟು ಬಿ ರಿಸರ್ವ್ ಫಾರ್ SC based on their population. See, ಇದು ಕರೆಕ್ಟ್ ಅನ್ಸ್ಬೋದು, ಬಟ್ ದಿಸ್ ಇಸ್ ರಾಂಗ್. ದಿಸ್ ಇಸ್ ದ ವರ್ಕ್ ಆಫ್ ಡಿಲಿಮಿಟೇಷನ್ ಕಮಿಷನ್. ಡಿಲಿಮಿಟೇಷನ್ ಕಮಿಷನ್ which is established under Article 82. So just like I said, ಪ್ರೆಸಿಡೆಂಟ್ ನ ಪಾರ್ಲಿಮೆಂಟ್ ಜೊತೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬೋದು, ಪ್ರೆಸಿಡೆಂಟ್ ನ ಗವರ್ನರ್ ಜೊತೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬೋದು, ಸಿಮಿಲರ್ ಆಫೀಸರ್ಸ್ ನ. ಸಿಮಿಲರ್ಲಿ ಹಿಯರ್ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ನ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಂಗಿದ್ರೆ ಡಿಲಿಮಿಟೇಷನ್ ಜೊತೆನೆ ಮಾಡ್ತಾರೆ. ಸೊ ಎಸ್, ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ನ ಮಾಡಂಗಿದ್ರೆ ಡಿಲಿಮಿಟೇಷನ್ ಜೊತೆ ಮಾಡ್ತಾರೆ. ವಿಲ್ ಮೂವ್ ಹೆಡ್. In the context of National Commission for Scheduled Caste, NCSC, I leave it to you. Constitution of India under Article 350B provides for special officer for linguistic minorities. Now you might have come across this, but if you have not studied, we'll see how it could be answered. But this is an important office, so it's better you study this, because there are only 3-4 things with regard to this office. That this office was established under 7th Constitutional Amendment Act, and it ensures that the linguistic minority rights are protected in the country and so on, and is appointed by the president and so on things. With reference to Comptroller and Auditor General of India, now CAG is an important office and you should know about this topic. Now his or her salary and allowance are determined by the president. Now like I said, CAG is an important office, and when the office is very important, I said Parliament would step in and not the president. So salary allowance, they are determined by the Parliament and not the president. He or she can be removed from office in the same manner as judge of Supreme Court. Yes, special majority in both the houses of the Parliament is needed to remove CAG. He or she cannot hold any other position within the government of India or any other state government after completion of his tenure. This is also correct. See, this has been done to ensure the independence of the office. This has been done to ensure the independence of the office. See that there are certain offices which are very important, which has substantial power when it is doing its part in the governance. So CAG is that one office, because he or she is called the public purse. So CAG office now, after their retirement or after they complete their tenure of CAG, we do not want them to serve under government of India or any state, because it could give rise to conflict of interest. So either important offices bandak, they do not have the right to serve again under the government. Okay, we'll move to next question. Consider the following statements with respect to CBI. Now CBI and ED, these are more important, so we'll have to have a look at it. So CBI is statutory body. See, CBI is neither a constitutional body nor is it a statutory body. CBI derives its power from Delhi Police Establishment Act, but it is not established under it, so it's wrong. Statutory body established under this act anidare, ee act under established agilla. Under this act, it derives its power, and it can take up so much investigation of offences anywhere in the country. Statement has been framed in a lame way. It can take up so much investigation, yes, of offences anywhere in the country. It can conduct investigation anywhere in the country, but with the state government's permission. See, there is something called general consent for CBI. 2-3 years ಮುಂಚೆ ತುಂಬಾ ದೊಡ್ಡ ಕಾಂಟ್ರವರ್ಸಿ ತರ ಆಗಿತ್ತು. CBI requires general consent. It requires consent from the state. There is something called general consent, and there is something called consent each time. So general consent means, for example, state of Karnataka will tell that, okay, CBI, we trust you, we will give you the general consent. So every time CBI wants to investigate cases in Karnataka, it did not ask consent again and again, because general consent has been there. But consent for each case wise, CBI sometimes, if there is no general consent that has been given by the states, for each case that comes up, CBI has to take approval of the state government for its consent, and only if state government gives consent can CBI it can conduct investigation in that particular state. Now CBI has been allegedly been used to promote the party politics of the center, and that is why many of the state governments which do not have the same ruling party as that of the center, those state governments have not given their consent for CBI, and this had become an issue. States like West Bengal, Karnataka, and so on other states where there is non-Congress, non-BJP party has been there, those states have not given their consent to the CBI. So superintendence of CBI related to investigation under corruption, it is under CBC. This is also correct. And this I said that this would be considered as wrong because anywhere in the country with the state government approval, without that it is not possible. So answer 1, 2 agate. See, next is question on Central Information Commissioner. Now this was important because there was an amendment in the 2019 where central government took most of the powers of CAC under it, that the salary of CAC would be decided by the central government, the tenure of the service of the CAC would be decided by the central government. It reduced the office of CAC from 5 years to 3 years. So central government through 2019 amendment reduced the powers of CAC and it took most of the powers under it. So idike 2019 agidke this becomes little bit important still. And one more thing, CAC has the authority to take disciplinary action against PIO. Whenever we want information, we go to information officers, then we go to PIO, then we go to CAC. So CAC has the power to take disciplinary action under PIO if they do not do their work well. And these officers are formed under RT Act, CAC, PIO, yella RT Act under in the established ಆಗಿದ್ದು. Again CAG, but simple question, I leave it to you. Chief Election Commissioner, simple question, I will leave it to you. UPSC constitutional body under Article 315, this is correct. See, Article 315 in the Article 323, this is related to UPSC. And usually yavagle ee tara bandru, the first article or the beginning article will provide for the constitution of that body or that office. Chairman of UPSC can be appointed as the chairman of State Public Service Commission after retirement. See, I told you that whenever we are allowing a particular office personnel to work even after their retirement, then there is scope for conflict of interest. Then their independence during their term of office would be compromised. There is good chances that it might get compromised. So we do not allow for this. Recommendations of UPSC are binding? No, they are not binding. So 3 is wrong. Answer becomes only 1. One more thing, a member of UPSC after completing term as the member, that person is eligible only for the office of chairman of UPSC. A person who is serving as the member of SPSC is eligible for the office of chairman of SPSC as well as member of UPSC as well as chairman of UPSC. So ee tara ide adu. Other than this permutation combination, others are not possible. Finance Commission Article 280, idu gottide. Distribution of tax, simple thing. Finance Commission recommendation. Finance Commission recommends measures to augment consolidated state of fund. This is correct. It does give measures based on the recommendation of State Finance Commission. This is also correct. So both the statements are correct. Simple question. Adre one more thing which I wanted to tell. See, Finance Commission recently 16 Finance Commission ಮಾಡ್ತಿದ್ದಾರೆ. Arvind Pingaria is the chairman, and also 15 Finance Commission. See, every time Finance Commission is giving its formula, it would consider different aspects before allocating resources among the states and among center and states. For example, forest, population, its fiscal measures taken by the state, population control measures taken by the state. So these kind of measures, whatever the state government has taken, it will give due weightage to each of these factors, and it will tell which state will get how much money. So 15 Finance Commission ಬೇರೆ weightage given to different components ಇತ್ತು, 14 ಅಲ್ಲಿ different ಇತ್ತು. For example, 15 ಅಲ್ಲಿ fiscal measures na boost ಮಾಡಕ್ಕೋಸ್ಕರ state government taken measures ಗೆ there was weightage that was been given in 15, 14th ಅಲ್ಲಿ ಇರಲಿಲ್ಲ. So 16th ಅಲ್ಲಿ ಏನಿದೆ ಏನು ಬರುತ್ತೆ, so ಈ ತರ ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. Even if you do not remember the percentage for each of these components, we should at least know which component is given more weightage and which component is given less weightage. ಅದನ್ನ ಅಸೆಂಡಿಂಗ್ ಡಿಸೆಂಡಿಂಗ್ ಅರೇಂಜ್ ಮಾಡಕ್ ಬಂದ್ರೆ ಸಾಕು. Okay, constitutional amendment, constitutional bodies. This is what I said. 89th amendment provided for separation of SC, SC, NC, ST. ಇದು ಗೊತ್ತಿರಬೇಕು because it is constitutional amendment, important topic, and it is constitutional body also. Now next is PESA. PESA Act, scheduled areas ಯಾವ್ದು. See, PESA Act first ಏನು ಮಾಡಿದ್ರು, ಪಂಚಾಯತ್ ರಾಜ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮಾಡಿದ್ರು. After PA was been done, we wanted the Panchayat Raj institutions to be extended to the scheduled areas which are covered under the 5th schedule. So 5th schedule areas ಗೆ extend ಮಾಡಬೇಕಿತ್ತು. So 5th schedule areas ಯಾವ states ಅಲ್ಲಿ ಬರುತ್ತೆ? There are 10 states and it is important you remember the 10 states. So based on that only this question has been formed. Assam comes under 6th schedule, so it does not come under this. Maharashtra yes, Odisha yes, Chhattisgarh yes, Andhra Pradesh yes. These 4 come under the PESA Act. So PESA Act under 10 states ಇದೆ. How do you remember this? Simple thing, if you remember India map, maybe then you can deduce it. See, Kerala, Tamil Nadu, Karnataka ಬಿಟ್ಬಿಡಿ. ಕರ್ನಾಟಕ ಮೇಲ್ಗಡೆಯಿಂದ ಕೌಂಟ್ ಮಾಡಿ. ಆಂಧ್ರ ಪ್ರದೇಶ್ ಬಂತು, ತೆಲಂಗಾಣ ಬಂತು, Maharashtra is included. Maharashtra, on top of Maharashtra, what do you have? Madhya Pradesh is included. Rajasthan is included. To the right of Madhya Pradesh, Odisha, Chhattisgarh. How many states do we count? One different thing which you need to remember is Himachal Pradesh. Himachal Pradesh is included. UP, BR, Ivala included illa. So in this, the states which come in under this zone, 9 states plus 1 Himachal Pradesh. So in this way also you can remember the 10 states instead of just rote learning. So that's what I keep on telling. Whenever you try to remember something, use some trick, because you never know on the day of exam when your memory may not support you. Simple question on Legislative Assembly of a state, I'll leave it to you. Model Code of Conduct, I spoke about it earlier also, I'll leave it to you. Delimitation Commission, simple thing, I'll leave it to you. Sorry. Okay, this is what I was telling. One more thing which I wanted to tell. Though the question is not been asked by UPSC, it is better that you know. See, states under Article 371. Based on that only this question has been formed. In the original constitution, Nagaland was the only state that had special provisions. One is only, and only Nagaland was been involved. If we had to give special provisions, then we would have given to multiple states, like 4-5 states, because most of the states at that point of time in the original constitution, they needed special provisions because they were more backward. So bari Nagaland itara irutte annadu wrong. In fact, this Article 371, which gives special provisions to certain states, it was added later. It was added by 13th constitutional amendment. It was not present in the original constitution. So acts of parliament relating to ownership and transfer of land would not apply to Nagaland unless the state legislature of the Nagaland decides, not the governor. Act of parliament, act of state legislature, if it has to happen on the governor's consent, then that would be called a 6th schedule area, not the 5th schedule area, not falling under special provisions. So it's not the governor, it is the state legislature. So it's wrong. See, Article 371 yadas barate, quickly we'll try to remember. How do you remember? Make some mnemonic. Article 371, state government exams are commonly they ask. See, 371 under important states which have made development, Maharashtra, Gujarat. Next, Article 371A in the 371J yaya states barate. You can make some mnemonics such as NAM, TASMAG, MAGK, where Telangana and Andhra Pradesh are interchangeable. So NAM, Nagaland, Assam, Manipur, Andhra, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. Article 371J, which is the last article, that is for Karnataka. So Itarano you can remember, this is not important for UPSC, but usually they ask it in state exams. It was just a trick, so I wanted to tell. See, OBC is a simple question, I'll leave it to you. Now other question on UIDAI. Aadhaar number is a proof of citizenship. I hope you know this. It is not a proof of citizenship. It is given to usual residents. Usual residents means someone who is residing in India, whether he is a citizen or a foreigner who resides in India for a period more than 6 months. So these persons are, for these usual residents, Aadhaar has been given, and it is not a proof of citizenship. UIDAI operates under MIT. This is correct. This is wrong. UIDAI established under Aadhaar Act. Istu ಗೊತ್ತಿರಬೇಕು. Financial intelligence unit, I'll leave it to you. Health tax. We have heard about health tax, but if we did not know about it in detail, how we could have deduced this question? Health tax, tax levied on products, on harmful health, public health products, tobacco, alcohol, sugary drinks. Seems familiar because we know that whenever the budget comes, we hear that the tax on alcohol, the tax on tobacco are already high, and often they are increased. This is what we come across. So we see others. Tax imposed only to increase government revenue. Anyway, it is wrong. Pakka wrong, no doubt. Voluntary contribution by citizens to fund health services. Okay. A tax on healthcare providers for providing medical services. See, healthcare providers, they are providing services also, and you are putting extra tax, so it will it will provide disincentive to provide services. So this is wrong. So e-federal body, health tax, we keep hearing about this thing. So e-federal, if we have to choose between A and C, we would have taken A to be correct. So simple thing, this is what health tax is. And recently WHO has taken a decision. It is called 3 by 2035 initiative. By 2035, WHO is asking its countries to increase its tax on 3 products: tobacco, alcohol, and sugary drinks. Recent budget has also increased the tax on tobacco and alcohol. Those who consume it would know. That was one of the disappointment for many people, like my friends. Okay, consider the following statements about NGT. Now NGT, simple question. We'll see. See, NGT established under NGT Act of 2010, correct? Why we established NGT? Because when it comes to environmental disputes, we do not want to wait much. We want to follow the principle of natural justice, and we want to resolve the case as soon as possible. Tribunal is mandated to apply principles of sustainable development. See, nodi generic ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಗೊತ್ತಾಗ್ತಿತ್ತು. NGT 2010 Act ಇದು ನೀವು ಕೇಳಿರ್ತಿದ್ದ. NGT has original jurisdiction over all environmental matters, but cannot hear cases related to WPA. Okay, cannot hear Wildlife Act. Okay, but it has original jurisdiction over all environmental matters. Now this is wrong. Now all anta ಅನ್ಕೊಂಡ್ರು ಇದನ್ನ wrong ಅಂತ ತಗೊಂಬೋದಿತ್ತು. We'll see why. Okay, chairperson of the NGT must be retired judge. This is also correct. The only statement which was incorrect among this is 3. So 3 element, the answer should have been 1, 2, 4. See, couple of things we'll know about NGT. NGT established under 2010 Act. Okay, so it becomes a statutory body. So NGT is supposed to resolve the case within 6 months, and it is mandated to do so. But despite the mandation, there are cases where it has not done this thing. NGT has the power. It can give binding decisions. It has the power to enforce decisions similar to civil code. So there are certain cases where NGT has put penalty also. For example, Yamuna Bank, ಅಲ್ಲಿ industries ತುಂಬಾ pollute ಮಾಡ್ತಾ ಇತ್ತು, flood plain ನ damage ಮಾಡಿತ್ತು. So it has put fine over these industries. Art of living case. So ಈ ಕೇಸಲ್ಲಿ art of living ಕೇಸಲ್ಲಿ NGT had put penalty. So NGT has that power to put penalty also, and it is supposed to resolve the case within 6 months, but many times it does not happen. But one drawback of NGT, whenever order is been given by NGT, but you do not like the order, you want to appeal, the appeal of NGT would directly go to Supreme Court and not the High Court. Supreme Court ಹೋಗುತ್ತೆ, High Court ಹೋಗಲ್ಲ, and this has been one of the drawback, because here we are bypassing the power of the High Court, and this is not something which is good. This is one of the drawback of NGT. With reference to digital colonialism, We might have heard about colonialism. This is digital colonialism, a familiar term. It is not very new. We'll see. Obviously, we wouldn't have come across it in detail. We might have heard the term. So how we could have got the question is correct. It refers to domination of digital ecosystem by global technology corporations through ownership and control of user data. See, idu correct ene. Idan yaro wrong anta helakala. It is a very generic sentence. We'll see the other statements. So one, we take one as correct. It involves the decentralized capture and monetization of data without explicit consent, undermining the state and individual autonomy. Just think of it. Idu nimige correct ansate. Yakandre, see, decentralized capture, it is not that it is capturing things from data from certain part of the country or from certain areas. It is doing in almost all areas in a decentralized manner. It is monetizing the data also, and often you see it is without explicit consent. There are so many hidden terms and conditions that we users do not come across it whenever we are using the social media sort of things, be it Facebook, WhatsApp, Twitter, and so on. So there is no explicit consent that has been taken. So individual autonomy as well as the state's autonomy to keep up vigilance is been bypassed. So this is correct. Third statement today, it primarily refers to use of military cyber operations to occupy foreign digital. See, made up statement. Primary purpose, statement 1 was the primary purpose. Statement 3 la. Statement 1 and statement 3 itself has been contradicting. So statement 1 and 3 cannot be together. Simple thing. See, obvious, many times you will see one statement is contradicting the other statement. So our statement irbeku atha ee statement irbeku. So here 1 and 3 are contradicting each other. So either statement 1 and 3, 1 is correct or 3 is correct. 1 and 3 together cannot be correct. So 1 3 together ಆಗಲ್ಲ, C ಮತ್ತೆ D wrong. Statement 1 correct ಅಂತ ಗೊತ್ತಿರೋ ನಾವು ಆನ್ಸರ್ A ಅಂತ ಗೊತ್ತಾಗ್ತಿತ್ತು. Moving ahead, last few questions. Question on Supreme Court, I leave it to you. Simple question. Okay, constitutional status. So this is a simple thing. I leave it to you. Importance of Panchayat Raj, simple question. I will leave it to you. Removal of judges. Even this is a simple question. Motion for removal of judges, 100 Lok Sabha members, 50 Rajya Sabha members, correct. 3-member committee, this is also correct. Removal of High Court judges follow a different procedure than that of Supreme Court, wrong. See, the detailed procedure for the removal of High Court or Supreme Court judges, it is not mentioned in the Constitution. It is mentioned in Judges Inquiry Act. So the procedure that has been followed to remove Supreme Court judge or High Court judge is a similar thing. And in India, as of now, till now since independence, no High Court or Supreme Court judge has been removed. This is another thing which we need to be aware of. Constitution explicitly mentions or uses the term impeachment and removal of judges. In test 2 also I said that one trick which UPSC gives traps is Constitution mentions this, Constitution provides this, Constitution talks about this, Constitution does not talk about this. Ee tara statements kodtare. So Constitution, most of the things it has not been mentioned. So mentioned andag explicitly irbeku. So explicit word kuda use madidare illi. Constitution explicitly uses the term impeachment. Impeachment is wrong. Impeachment is been explicitly used for the president. For judge, it is not been used. So this becomes wrong. This is what is the trick thing that is there. With reference to Latin America, see, I said mapping is important. When I was doing the geography discussion part, I spoke about this. See, South America. So which are the countries coming? Which country lies here? One broad idea irbeku. So Chile left side igide, Pacific agate. Uruguay right side igide, Atlantic aate. Bolivia is a landlocked country. It does not open up. Venezuela, which is at the top, will come to the Caribbean. See, there's nothing to discuss in map sort of questions. You need to be aware of it, and you need to put decent amount of effort to remember those things. Brazil idu. See, I told about this. BRICS, international organizations like BRICS, BIMSTEC, which is the new member that has been recently added, or the new initiative that has been taken. So ivalla we should be aware of it. IR current affairs al barate. Term Girmitia, I saw the options, there was no way of reducing it. So it was better meant to be skipped. It trick work ಏನು ಮಾಡಕಲ್ಲ because the options formed are difficult. See, options, statements formed if it's easy, then we can deduce it. we couldn't have deduced it. Consider the following statements with respect to Kaladan. Kaladan we've been hearing from so many years, but if we did not know about it, or if we had forgotten it, just remember that Kaladan transport, it is sea, river and road transport. There is no railway involved in Kaladan. So rail anta helidare, idu wrong agate. So idu wrong agidre waterway, Sitwe to Paletwa. From Indian part to Sitwe port we go through sea, and from Sitwe to Paletwa we go by river. Adine waterway anidare. River anta kuda helidare, waterway. So idu correct ani gottittu. 1 correct, 3 wrong. 1 correct, 3 wrong, 1 and 2 are correct. So option A ಮತ್ತೆ C ಮಧ್ಯ guess ಮಾಡಬೇಕಿತ್ತು. In case if you are forgotten studying about Kaladan. See, International Criminal Court, you please go through it. All I wanted to tell is, one is International Criminal Court, one is International Court of Justice, one is Permanent Court of Arbitration. So you should know differences between each of these three. International Criminal Court, it will take up things such as genocide, crimes against humanity, crime of aggression. Mostly individual against ಏನಿರುತ್ತೆ ಅದು ICC ತಗೊಳುತ್ತೆ, country against ಏನಿರುತ್ತೆ ಅದು ICJ ತಗೊಳುತ್ತೆ. PCA is general. Most of the things which ICJ would take, PCA would take same. Country against ಏನು crimes ಇರುತ್ತೆ ಅದು PCA ತಗೊಳುತ್ತೆ. India is a member of ICJ and PCA. It is not a member of ICC. Not just India, even other important countries are not member of it. But see, ICC has been established under Rome Statute, which entered into force. We will not remember as to which body came into force in which year, and mostly there is good chance that they might give a trap in this. So we take this as wrong. It is better you take it as wrong. See, in 5 times if you do this, 3 times at least you will get it as correct. ICC is permanent international country to prosecute individuals, is okay. India is a member of ICC, wrong. Like I said, India is a member of ICJ and PCA. India Pakistan issues, we go to PCA, or if we have issues with other countries we go to ICJ, but not ICC. ICC can exercise jurisdiction only when a state is unwilling or unable to prosecute crimes. This is correct. When a state is unable to prosecute crimes within its domestic area, then ICC can exercise its jurisdiction. And that too, only countries which have accepted or signed the ICC agreement, only in those countries can ICC step in. Since India is not a member of ICC, if there is some issues happened in India, if some individual in India commits a genocide crime, then ICC cannot step in India because India is not a member. ICC headquarter is in Geneva, it is land. See, facts ಆ ಥರ ಬಂದಾಗ double check ಮಾಡಬೇಕು, because facts ಅನ್ನೋದು wrong ಕೊಡ್ತಾರೆ. Be it data, place, date, these sort of things trap ಕೊಡ್ತಾರೆ. It is not in Geneva. I think it is in Hague, Netherlands. So ಈ ಮೂರು ಡಿಫರೆನ್ಸ್ ಒಂದು ಕಲ್ತ್ಕೊಳ್ಳಿ. We'll move ahead. Those things you will come across with IR current affair in the IR magazine that you study. Simple thing, Red Sea maintenance mapping question, I'll leave it to you. New Caledonia, I don't think this is that important, so I'll leave it to you. PM Dhanadanya Krishi Yojana. If you have studied this question, then you would be able to answer it. If you did not study this question, we'll see how you could have answered it. So PM Dhanadanya Krishi Yojana Dhanadanya, okay, enhancing agriculture productivity through modern inputs and mechanization. Simple statement. So there is nothing wrong in that. So statement 1 correct. What about others? Encouraging crop diversification and promoting sustainable farming practices. PM Dhanadanya ಅಥವಾ ಇದೇ ರೀತಿ 4-5 ಸ್ಕೀಮ್ ಇರಲಿ, the first 2 statements ನೀವು ಮೇನ್ಸ್ ಅಲ್ಲಿ ಏಮ್ ಆಫ್ ದ ಸ್ಕೀಮ್ ಆರ್ ದ ಬೆನಿಫಿಟ್ಸ್ ಆಫ್ ದ ಸ್ಕೀಮ್ ಅಂತ ಬಂದ್ರೆ, PM ಧನಧಾನ್ಯ ಇರಲಿ ಅಥವಾ ಯಾವುದೇ ಸ್ಕೀಮ್ ಇರಲಿ ಅಗ್ರಿಕಲ್ಚರ್ಗೆ, ಫಸ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಆರ್ ವೆರಿ generic. Crop diversification, sustainable farming, increase agriculture productivity. There is nothing wrong in this. Most of the schemes will aim for this. So statement 1, 2 correct. Augmenting post harvest storage capacity at panchayat block level, which is the lowest level which is needed. So idu kuda correct, because post harvest storage, this is one of the issue which we face and we want to develop in that area. Providing long term overseas market access. One is the long term, which needs double check. Overseas market access for Indian agriculture products. See, overseas market access, it's not just in the hands of India. We need the other country also to agree for it. And sometimes even if they agree, after a certain period of time, due to some geopolitical issue between India and that country might even close the market for Indian agriculture produce. So this is a promise which Indian government cannot do easily. So option 3 is wrong. The rest of the options are correct. See, RBI Act, simple question. What I wanted to tell in this is FSDC, Financial Stability Development Council, I suppose. Now this body you should know about it. FSDC, the chairperson is chairperson for this body is FSDC. I think it's the finance minister. Please check it. And the members are all chairpersons of important bodies. Chairman of IRDA, chairman of PFRDF. All these are members of the important FSDC body. The main aim is to maintain financial stability in the country. Likewise, RBI reports. RBI comes with financial stability report and other reports. Please be aware of it. Another thing is FRBM provisions. I told in earlier sessions also there is FRBM Act 2003. There was NK Singh committee which added amendments in the year 2016. And to 2018 amendments, FRBM Act was been amended in the year 2018. And so many new provisions have been added like escape clause, change from fiscal deficit to debt to GDP ratio. Debt to GDP ratio overall needs to be 80%, where overall needs to be 60%. 40% debt to GDP ratio needs to be maintained by the center. 20% debt to GDP ratio needs to be maintained by the states, and these things to set up independent fiscal council. And these are the things which have been said by 2018 amendments in FRBM. So FRBM Act, please make a note of it. I discussed it earlier also, and please ensure that these provisions of FRBM are in your notes, because these are important both for prelims and mains. See, double helix model, this was just been asked in the question. This is not that important of a question. The answer to this is this. This is left to you. This is not that important question. So see, we completed the discussion of this video. Like I said earlier also, there were certain parts which are important. Supreme Court, or you take there were so many topics: Supreme Court, governor, any constitutional bodies like Election Commission, UPSC. These were more important bodies. There were questions on lesser important bodies also. For example, National Research Foundation. It's in news, that is why it is important. But there are so many other bodies which have been asked in this also. You need not dwell too much into it. So UPSC Wodi, Election Commission Wodi, but Special Officer for Linguistic Minorities Kadme Wodi, NCSC Kadme Wodi, NCST Kadme Wodi. Members ಮೇಲೆ ತುಂಬಾ ಜಾಸ್ತಿ UPSC ಫೋಕಸ್ ಮಾಡ್ತಿಲ್ಲ. ಸೊ ತುಂಬಾ ಜಾಸ್ತಿ ಅದನ್ನ ಮೆಮೊರೈಸ್ ಮಾಡ್ಕೊಂಡು ಬ್ರೈನ್ ನ ತುಂಬಾ ಜಾಸ್ತಿ ರಾಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ. Just ensure what is that it does. For example, NHRC, what is that important provision or specific provision with respect to NHRC? For example, any crime that has been committed, but it has been more than 1 year that the crime has been committed, then you cannot approach NHRC, because once the crime is committed, within 1 year you need to approach NHRC. So this is very important specific fact about NHRC. But too much dwelling each and every provision, memorizing each and every members, this is not needed that much. So in this paper, if you got less marks, do not worry, because there was one, just ensure that whether did you make mistake in that important part or whether did you make mistake in less important part. Important part and mistake madra, you need to revise. There is little bit that you need to worry about. Less important parts and mistake madra, it's fine. UPSC itself will ask less questions on that. So adral mistake madru kuda in the actual exam paper al question e bardegidre ನೀವು mistake ಮಾಡೋದು ಸರಿ ಮಾಡೋದು ಮ್ಯಾಟರ್ ಆಗಲ್ಲ. So this is what I wanted to tell. Thank you for watching the discussion video.